things can go wrong.
And do go wrong, don't they?
And they do go horribly wrong.
These rights can now all attach to this, which means legal recourse for crypto fraud victims, doesn't it?
Very exciting set of rules.
Very exciting set of rules, and they've become a bit, because there have been so many amendments, they're almost a bit of a Frankenstein's monster of rules now, aren't they?
I think one of the ways we love that how service was made was by NFT, wasn't it?
Airdrop by NFT into the wallet of the suspected,
which is brilliant.
fraudster. They said, look, you can't, there's no identifiable cryptocurrency here. You can't identify specifically, oh, that's Fabrizio's cryptocurrency. Let's look at solutions, not problems.
Exactly.
Come on, let's look at solutions.
So
these are classic legal principles, but they are applying to very or relatively new technology.
Yeah.
Good afternoon, Kieran. How are you doing today?
Hello, Roman. Yes, very well. Yeah,
Good,
not too bad at all.
Warmed up since our last podcast.
I think so. Yeah, feeling sprightly, feeling ready for this legal recourse podcast.
Yeah, so we're looking today at basically if you've suffered crypto fraud, so if you've had your cryptocurrency stolen, what can you do, crucially, to recover it? What are the steps you can take? And there have been a lot of interesting cases going through the courts in England and Wales, haven't there?
Yeah, they have. Absolutely. I think England and Wales have been the real driver with all of this. And again, this comes on to because we're such a major player with cryptocurrency.
Yeah, that's right. We've got this, I think, the third largest transaction volume in cryptocurrency globally. Incredible, absolutely incredible.
Yeah.
But when you're transacting that amount of cryptocurrency,
things can go wrong.
And do go wrong, don't they?
And they do go horribly wrong.
We've spoken before about sort of types of things that, types of fraud that can occur, and obviously speaking with Scott Pounder from FTI Consulting, on another podcast about, actually looking at these in practice and some war stories, as it were, tales from the
which we'll be looking forward to that one, because he'll give us some insight into how you actually how you trace these stolen assets,
the forensic side of it. So that's exciting. But I say maybe warm off the press. We have this now. This is, well, first of all, it's paper, it's hard copy, but this is the Deloria decision. So this one, the court's, we've spoken about Deloria before in a previous podcast. We've done some articles on it. This was handed down on the 12th of September of this year, relatively recent. In terms of case law, it's very recent. Now, we'll delve into that case in a bit more detail in a moment, but why it's relevant is it deals with a lot of these issues around currency and digital assets as property and the rights that flow from that. So now it's been established as a third category of property. It means you can trace it, you can bring a claim to cover it, you can bind other people to various legal remedies, whether it's unjust enrichment, constructive trust, whether it's you're looking at following or knowing receipt of dishonest assistance, whatever it might be. These rights can now all attach to this, which means legal recourse for crypto fraud victims, doesn't it?
Absolutely, which is a nice link back to our podcast subject today. But no, that's right. We've established it's property. And we know it all. We know it is. Everyone that has crypto will definitely feel as though it is their property, especially when it's been stolen. Because we know that there's a value there. So yes, there's a lot of ways you can help yourself through the common law, which the listeners may not know what that is, but effectively going to the courts and asking for assistance and help.
Usually you have to do it because the fact is, if someone, I say usually if it's proportionate, because if someone's stolen cryptocurrency, they're not going to willingly give it back to you.
No.
Yes, the first step is you contact your bank, your trading platform, let them know immediately, see if they can put any stops in place. You contact the police, action fraud specifically. If it's someone who's trading as a financial entity, contact the FCA, the Financial Conduct Authority, and those are your kind of more your criminal and regulatory avenues. But in terms of actually recovering it, if you can't do it through the criminal remedies, then you have to pursue it through civil means, and you have to. The key is acting quickly here, isn't it?
Yeah, absolutely, and getting the right people on board. We've said this time and time again, but you need to find those people that can actually trace the crypto, because you don't know who the defendants are, who the fraudsters are. Which is why often you get it'll be you against persons unknown in a civil case, because no one will know who they are. And oftentimes they still don't know who they are, even right through to the end stages.
And that's it. So let's say you've got, I don't know, 10 Bitcoin. that have been stolen,
worth $1 million.
100 Bitcoin, whatever it is that's been stolen. What do you do? What do you do next? I think first of all, you've got to think about an injunction, a freezing injunction, don't you? And then because what you want to do is to stop any further steps being taken.
Yes.
And get details and information of who's done this.
That's right. Yeah. And what's been useful is that the courts have effectively forced exchanges to help with that and give information as to where those assets may have gone, so that you can then freeze whichever accounts or wallets or wherever that stolen asset has been traced to. You can freeze it while you then get your ducks in a row to actually get it back.
Exactly. Yeah. The courts have confirmed you can do these without notice applications. So that means you don't need to give notice of this because of the urgency, the type of claim it is, to the other parties. And frankly, how could you give notice to them anyway, generally speaking, unless you've traced them in the first instance? So many of these cases are cases against persons unknown because they are unknown.
Yep.
They are unknown. Or it's one person, it could be a group of people, it could be a series of developers, whoever it is, that's the issue. So I think that's it. Firstly, you look to apply for a freezing injunction and then some form of disclosure order to get, if it's the trading platform, for instance, and if the money, and that's often what you get. You often get people hopping through various platforms and exchanges.
Yes.
So if it's a platform or exchange, getting a disclosure order against them. And there are two broadly speaking on there. There's the Bankers Trust order, which takes its name from Bankers Trust and Shapiro, which is a 1980 case, and then Norwich Pharmacal order, again from the eponymous case. And effectively what a Bankers Trust disclosure order does, it's an order which basically authorises and requires a financial institution, usually a bank, but it doesn't have to be, an exchange, a trading platform, or peer-to-peer, so digital asset marketplace, to disclose information about customers in circumstances where it's believed that a fraud has been committed by them, and it allows you to trace the assets. Norwich Pharmacal orders are similar, but it's an order for disclosure by a third party about information which might allow a claimant to plead a claim. So it's not necessarily about the identity, about the case. But the point is, what we've seen in a lot of these cases, you've got Osborne, you've got Jones and Persons Unknown, you've got Tulip Trading, Deloria, and so the courts are open to these applications. This is how you go about doing this, and then you've done that, and then you've prepared the application. You then need to serve it. How do you serve a claim on persons who are unknown, who may be anywhere in the world? He says with a loaded question.
Exactly. Well, sir, this is it. The lawyers in the room will understand this, but there's certain formalities to actually show and bring that you have a claim and deliver that to the person that you want to restore your assets from, or if it's persons unknown, an exchange or whatever it may be. So there are gateways, what we call gateways, which allow you to do that. And I think the courts have been extremely flexible here, and which has been great because, yes, if you go back to the start, this is property, it's been stolen. A judge will be looking at this and saying, well, hold on, there needs to be some kind of restitution.
So a pragmatic solution as well.
And deliver it back. So
these gateways then, they're within the civil procedure rules. So these are the rules that govern civil litigation in England and Wales.
Very exciting set of rules.
Very exciting set of rules. And they've become a bit, because there have been so many amendments, they're almost a bit of a Frankenstein's monster of rules now, aren't they? But you've got to know your way around them quite well.
Yeah, you do. Yeah.
But these gateways allow you to serve proceedings or actions out of the jurisdiction in a more streamlined manner, using one of these gateways, or basically permitting you to serve these claims by using one of these gateways. And they've recently added more gateways in because of in the light of these cases. So that's really helpful.
I think one of the ways we love that how service was made was by NFT, wasn't it?
Airdrop by NFT into the wallet of the suspected,
which is brilliant.
Fraudster.
Using digital assets to recover digital assets.
It's great. And I saw the NFT. You can Google it. I think that was in Jones and Persons Unknown.
Yeah.
Really, hats off. That was certainly not intuitive, but a really good way of doing it. Yeah. And other ways have been released by email or
as simple
we do that quite regularly.
Yeah, we do. But we say it sounds simple, but it's not. You do have to show to the court that actually the way you're trying to serve will be effective or should be effective. And in these cases, I like that the courts have taken that flexible approach and said, here's you've given us an email, let's try by email.
Yeah.
You've said it could be done by NFT, let's try that.
Yeah.
Yeah, because you have to serve your claim. That is something that you do have to do under the CPR. You can't just say yes, I've got a claim, and now I'm getting my stolen crypto back. So yeah, no, it has been very positive, which is great. Yeah, but I think it goes back to, I think it's important for the listeners to know that there are legal recourses there, both criminal and civil.
Yeah.
And on the civil side, it's about getting that back.
We've potentially frozen.
Yeah.
The wallet or the relevant part. We've got disclosure, so we can start to identify them. We've engaged forensics team to locate these. And so next, I guess we need to trace.
That's it.
This
yeah.
asset, don't we?
It's so you trace it, you find out where it is, and then you enforce.
And so you've got the sort of claims you bring. When it comes to tracing, you're basically looking to argue that wherever those funds have ended up, because it may not, the chance that they've been moved so many times, they may not be with the fraudster anymore.
No, they're with someone else.
Them. Yeah. So you're tracing them usually by proprietary remedies. So you're saying they belong to you. You've got proprietary right over those specific assets, and what you're arguing is that those are then held on what's called a constructive trust.
Yeah.
For you,
for the original owner.
Yeah. So there's a fiduciary relationship, but they are owned, or they're held by the recipient on a constructive trust for you, tracing them to try to recover them. And there are other equitable remedies. One thing that's often argued is unjust enrichment. Someone sat there with these, as they've been unjustly enriched by your assets. You've got to show a defence to unjust enrichment as they've been a change of position, or it's not unjust enrichment because actually you paid.
Bona fide purchaser.
Yeah, exactly that. But these are the sort of remedies that are available. And like I said, they've been going to court. You've got the lawyer was there. This was the first. It's a big case because it's the first one to actually go to trial on an issue, because a lot of them were just interim applications.
Yeah.
And there again, we've just done a podcast on the digital assets, etc. bill, property and digital assets, etc. bill, but the lawyer again just confirmed that a digital stablecoin is property for purposes of being able to try to trace it or to argue these remedies and reliefs, even though it doesn't fall within the definition of a thing in action or chosen action or a thing in possession. It's still property.
Yeah.
So that was an interesting case. I've got it.
And that's recent, isn't it?
September.
September 2024.
Yeah.
And Court of Appeal? Up to court?
High Court.
High Court.
Yeah, High Court. But it was interesting case because there you had Fabrizio, the lawyer, or that lawyer, rather. So he's not a lawyer. That's just my dreadful pronunciation of his surname. So apologies, the lawyer.
It is D''.
D''ALOIA, not as in the lawyer. But so apologies. But there he was the victim of fraud. He had about £2.5 million of cryptocurrency stolen, and that they were obviously taken by persons unknown, who were purporting to be TD Finan. They weren't, and then they were obviously transferred across various addresses on the blockchain. So he commenced these proceedings against these persons unknown for deceit, and also brought in a number of crypto exchanges as well. And what he argued was that they were liable on the basis of unjust enrichment because they'd had these or held these funds, or alternatively at the same time as constructive trustee, because they, in holding these assets, they had a fiduciary duty to him, and they failed in that duty. And then he had one of the claims, he actually settled a claim against Binance, which was interesting. So they didn't go to trial, but now, obviously, it went to a 5-day trial. He had a claim, one of the defendants was a Thai-based crypto exchange, BitCub Online, and they defended a claim on the basis that they said that you couldn't identify any of Fabrizio's cryptocurrency.
The original.
Yes, you couldn't trace it because it wasn't identifiable. Not as if it's. I won't go into too much detail because I don't want to bamboozle bore people. But effectively, if they're mixed fund, your tracing remedy depends. If it's a claim in equity or common law, but it's more difficult if they're mixed funds, or you look at sometimes principles of first in, first out. And so they successfully defended the claim on that basis, they said, look, you can't. There's no identifiable cryptocurrency here. You can't identify specifically. Oh, that's Fabrizio's cryptocurrency.
Yeah.
So tracing doesn't apply, and then nor did they say do they own any fiduciary duty, and there's no unjust enrichment. And so the High Court dismissed those claims against BitCub because what they said is that he'd failed to show that any of the cryptocurrency was identifiable.
And even held with them. I'm sure he probably had good cause to say that it was.
They did, but the problem was in that case was actually, and the judge was quite scathing of the expert evidence and said that the experts, while saying that they had clearly traced them, and they hadn't really proven. They hadn't really shown a detailed picture of how these assets were traced. But they held that the USD tether was property, and again, as this has already been confirmed in previous cases. But look at this. It did. The High Court did say that the common law isn't limited to tracing methods that have previously been identified, such as the first in, first out rule. So it looked to develop that area. It said there was no constructive trust, but not necessarily that a constructive trust can't necessarily arise in the future,
right?
As it has in other cases. It was a useful case, a really useful case in that regard. Now, that was, like I said, that kind of looks at those potential remedies available. Another really interesting one, which I like, which we've spoken about before, but was Tulip trading, where there were significantly more was stolen, and they were effectively, so there the Court of Appeal held Tulip Trading's appeal, which reversed the first instance decision, which was effectively saying it was only on a preliminary issue, but arguing what Tulip Trading were trying to do was to say that the developers of this exchange owed a duty to Tulip to release a patch to allow him to be able to recover his stolen Bitcoin.
Yeah. So he could show that he could recover it if this patch was implemented. It's a software patch.
And the defendants argue, look, as a software developer, we're movable. We're not a set group of people. We can be hundreds, we can be thousands, we can be one. We change, ever-changing group of people. And the Court of Appeal said, bear in mind, this was just a preliminary issue of whether it could serve his claim, pursue his claim, but it said that there's an issue that has a real issue that deserves to be argued at court, and therefore it's one that he's permitted to serve his claim on and to pursue further. So again, an interesting one, because it suggests that there's a possibility that as a software developer or blockchain developer, you might owe a fiduciary duty if someone's assets go missing. Now that's not what the case said, but it said there's a triable issue there.
Yeah, of course. Yeah.
So I've gone down the rabbit hole of that. But in terms then, so let's say you've done this, you've established this, you've served your claim, you've been able to trace, you've got your freeze injunction, you've been able to get an order from the court confirming that those assets belong to you. So how do you enforce? What's the
So as with all of these, if you have a claim to bring, great. If you think you can rely on the argument successfully to actually get a judgment in your favour, great. But then can you enforce it? So if you find someone that has, let's say, been fraudulent and they are penniless and your crypto is nowhere to be seen, what are you going to enforce against? If you're trying to use a third-party debt order or whatever it is to go against their assets, may not be the crypto that's been stolen because you can't find it. Let's say they own a house, whatever it may be, and they don't have any of those assets that you can attach that to, then what's the point, quite frankly? So you do have to be quite careful.
But you can, but the point is,
you can. So let's flip it on its head. If someone is...
Let's look at solutions, not problems.
Exactly.
Come on, let's look at solutions.
So third-party debt orders is a classic one. If you can show that someone has money that can pay that back to you, you've shown that they've done something wrong, that comes back to you. The obvious one is that if the crypto assets can be located, you can ask for those to be returned. Now, a lot of time, what actually happens is the exchanges will return it back, and it's converted into fiat pound sterling in our case in this jurisdiction.
And that's a really useful one, actually. That
popped
one
into the court
isn't it?
funds office.
Yeah, because for instance, in the Jones case, I think what they were able to do, not only to secure the Bitcoin, but they were able to secure a costs order against that wallet and the fraudster's holding. So not only did they get their money back, they're able to get a proportion of their costs back as well in Bitcoin.
Yeah.
Now, I don't know whether they've held on to that Bitcoin, but it's rocketed up in value since since Trump got re-elected and since Musk has joined his task force. So
that's an interesting point you raised, because the costs of bringing these proceedings they'll differ between the facts of each, but they're not cheap.
It has to be proportionate.
It has to be proportionate, yeah. So you not only can you get enforcement of the actual restitution of the assets back to you, but also you can get your costs.
Yeah.
Hopefully a good proportion of them back as well.
Yeah.
Which is really useful. Yeah. Other ways of enforcements would be mandatory injunctions that requires the code to be written or transferred back.
Which is, again,
is the software.
The Tulip case, yeah.
Exactly. And with all of this, it's, can you find it? Can it come back to you? Can you actually enforce it? So can the enforcement take place? Are you going to help?
And this is it. These are classic legal principles, but applying to modern technology, and that's it. And two reasons that. One is that they are classic legal principles, and whether they're principles in what's called equity, like your fiduciary obligations, jargons, or with tracing, or whether it's statutory or following common law. But these are classic legal principles, but they are applying to relatively new technology.
Yeah.
And so the key is to make sure that the team of experts you've got around you to help you with this, yes, they know the classic law, but that they understand it in the context of this technology.
That's it. And I think with this area, it's having the right contact. Yeah. First of all, the right investigating agent to find it. Yeah. That's so key. Someone that can get on with it pretty quickly. Like Roman said, we're speaking to someone called Scott Pounder later on in a later podcast. And that will be interesting to see how he has successfully found these assets. And then it's over to us to do all of these little nitty-gritty applications to show the court that it's there, using that investigation work, and then it's getting it back through whichever means possible from an enforcement point of view. So, there's a couple of key stages. And I think then also you're dealing with companies such as exchanges, wallet holders they have had to get used to this very quickly, but I think they are probably still implementing their own policies and adjusting their policies as to what happens if they are named as a party to the proceedings that can either help, or if they're named as defendants because they've done something incorrect, which has allowed the fraud to be taking place.
And I think what's useful as well is that this is available for people in England and Wales because A, the courts have accepted, but B, if you are resident in England and Wales, it doesn't matter where your Bitcoin's in the cloud or wherever, that doesn't make a difference. What so the law or the courts have said here is that the jurisdiction is basically where you're based. So it's not where the Bitcoin might be. So if the Bitcoin be transferred to a wallet in Mauritius, as was the case, or in one or Thailand and the other, then it doesn't matter. If you're here in England, Wales, the jurisdiction is here. Certainly that's what you'd argue. Yeah. And
which allows you to then bring English proceedings, doesn't it? Which allows you to hear it in the English courts. Yeah. Which allows you to be in front of a judge that is flexible with all of this and have, we think, been the leaders in actually in advancing this area of law. Yeah. Being able to trace, recover and enforce. Yeah.
Super. All right. I think that probably wraps up our run through on obviously what the legal options available if you suffered a fraud, and stay tuned because we'll be speaking to someone who's been at the coalface in our next podcast. So thanks very much, Kieran.